Thank you for joining. I guess we'll get started. We're going to start shortly. We're just run through a couple of the administrative things. So my name is Julie Honor. I'm counsel in our in Thompson Hine's corporate practice group in our Chicago office. Joining me today are my colleagues Francesca and Guerrero, a partner in our international trade group in Washington, D.C., and Tanya Nesbitt, a partner in our environmental practice in our Atlanta office. We want to welcome you to today's webinar. We'll be discussing sustainability claims related to greenwashing, social, and AI washing. And,
hey, Julie,
yes.
I'm sorry, Diane. We also want to mention quickly that today's presentation is being sponsored by David Cohen, Robin, and I'm sorry if I say this wrong, Canaston and Sonia Reddy. So I just wanted to thank all of them for everything they did to put this presentation together. And they're all on the line with us today. So thank you.
Yes, thank you, Diane. Appreciate you for saying that. Absolutely. And to the Honeywell team, you all have been fantastic to work with, and thank you for having us and bringing us in. So a few housekeeping items just before we get into the details. Today's program is going to be recorded. We'll send a link to you within the next few days. Presentation is intended for general information of individuals and organizations on matters of current interest. Thoughts and opinions expressed today are those of the individual panel members only and do not necessarily reflect the opinions of the panel members' clients, employers, affiliates, or Thompson Hine. Content should not be taken as advice, as the views expressed here are for informational purposes only. If you have a question, please feel free to use the question box. I know you all found it because you could tell us you could hear us through there. Thank you again. We really appreciate that. And we'll answer as many questions as we can at the end of the webinar. And CLE credit for today's webinar is pending. Be sure to complete the verification of attendance survey. The link to the survey is posted in the chat. I don't know if you're able to see that. It sounds like you might not be able to access the chat. And so we'll make sure that we send around the links to everybody that is here today as well. I will announce the attendance tracking code at the end of the program, and you will need that code to complete the CLE form that we will circulate to you. And just a note, you'll want to make sure that you stay online for the 60 minutes so that you get the full CLE credit. So that is the administrative stuff that we don't have to deal with anymore. We'll just quickly introduce ourselves. My background and practice focuses on the commercial contracting space and the AI space, working with clients of various sizes and industries on moving their businesses forward. Francesca, do you want to go? And then Tanya, since you're kicking us off substantively, we'll end with you for intros.
Sure. I'm Francesca Guerrero. I'm in the international trade practice, and one of the things I spend my time on is forced labor and human rights issues. So I'll be talking about social washing, which is the sort of forced labor version of greenwashing and AI washing.
Good afternoon, everyone. Tanya Nesbitt. I am a partner in our environmental practice. I work a lot on ESG or sustainability issues that intersect with our environmental work, and one of those includes greenwashing, which I'll be speaking about this afternoon. And with that, I think we can begin our presentation. So thanks, Julie. So one of the things I often get asked is, what does greenwashing mean, and sort of where did the term originate from? And so unfortunately, in the United States, we don't have a consensus on a definition. But we know in the 1980s, there was a gentleman by the name of Jay Westerfeld who used the term, or coined the term, to call the hotel industry out for what he thought was a misrepresentation or conduct that wasn't necessarily truthful, or perhaps was disingenuous, when they started a Save the Towel campaign for hotel guests. Many of you probably see these signs in your hotel today as you travel, and the hotel campaign was coined as one that would save the planet, right? You don't have to change your bedding or your linens daily, and not doing so saves water, But he looked a little deeper and saw that the true impetus or the true goal behind the hotel campaign was to save the hotel money and not really tap in or focus on the environmental benefit of reducing water usage. And so that term has stayed with us today and is used generally when a company's sort of stated intentions or goals do not align or misalign with its conduct. Many would be wise to note that a lot of this obviously started as really a grassroots effort, right, to ensure corporate accountability and has really, I think, sort of been an outgrowth of that type of movement or protests that we see today in either litigation or in corporate America with different shareholder disputes. Next slide. So given the political climate in the US, we have clients obviously that have kept the ESG title. Again, ESG standing for environmental social governance for those that may not be familiar. We have clients that have shifted to use sustainability as a term, and there are others that may not use a term at all, or they may call it community engagement, or they may call it corporate responsibility or corporate social responsibility. But at the end of the day, irrespective of what it may be called, it's important to note that greenwashing risk within a company really touches on multiple areas. And that really is kind of a big takeaway of today's presentation. Depending on the business, right, there could be misalignment in HR, right? There's something that, a term that Gen Z has coined in respect to companies' misalignment with respect to benefits or policies, right? So there can be washing on different types of leave, for example. Certainly in the operations category, you do have to think about social policies, which Francesca will be talking about later today. We could have it in tech, right? It's called AI washing. And as you get into legal and environmental health and safety, that's typically where you may see more of your traditional greenwashing with respect to environmental benefit claims. But it's just important, I think, to have a wide lens when looking for risk or potential risk mitigation, and that you're not sort of analyzing these issues or their potential impact in silos. Next slide, please. So we see that there's been somewhat of a generational shift, if you will, in terms of attitudes towards sustainability and these types of issues, which I think in some ways proliferates much of the risk. And so we see that Americans, when polled, tend to respond positively to companies that want to measure, think about, reflect upon the environmental impact their business is having or the social impact their business is having on society. We see that companies that sort of align with their stakeholders also tend to perhaps be more thoughtful, more organized, and tend to also perform better financially, right? Which I think was much of the impetus of some of the development of ESG or sustainability or corporate responsibility, whatever you choose to call it in corporate America. Next slide, please. And then we see that also that those attitudes and those expectations have also kind of translated as well into the workforce. So we see that employees tend to want to work and stay with companies that are perceived at least to be more socially responsible organizations and tend to be thinking about, again, the environmental impact or the social impact that the business is having on the environment around it. And we see that that also translates for most companies into better financial performance. And so that kind of has created the storm that we've seen in the last year, where we have in the last few years, where we see consumers really showing up in the marketplace and asking perhaps different questions than they asked in the past, and wanting to know more information about the products and services that they're buying and perhaps how that product or service may then impact the environment. Is that going to be a net positive impact? Is it neutral, or is it going to be negative? And if so, sort of what is the company doing to ameliorate that or to improve the performance? Next slide, please. So there are many different types of greenwashing. That's something I think too we have to have a wide angle lens on. So within the environmental space, I have to admit that we have lots of jargon, lots of acronyms, right? And that can be very confusing. The average consumer may not know necessarily what biodegradable truly means. There's certain terms of art or certain scientific terms that sometimes we may use to describe products, and that can create a lot of confusion for the consumer. And so when you look at the body of greenwashing case law, the courts typically start with a conversation as sort of what are what is a reasonable consumer's expectations, if you will. And so I think it's very important to be thinking about those things and mindful of those things as you work with marketing to label products, for example. There can be different inconsistent organizational practices as well, different ends of the business perhaps not necessarily aligned on how they may be communicating or working with the public or the community. The vagueness is also a very salient issue that we see as well in terms of the marketing or speech used to describe different goods and services. And then obviously there's sort of the outright lying, which may be oftentimes negligent, right? Consumer expectations in this area have also changed quickly, and we have terms that maybe we weren't using 10 years ago. So 10 years ago, you'd be hard pressed to maybe hear companies talk about net zero goals, for example. And then over time, expectations and policy has changed. So, maybe 10, 15 years ago, we didn't think of the chasing arrow symbol as misleading. But now in particular jurisdictions, it is considered misleading if the product has not met the stringent standards of recyclability for that particular jurisdiction. And so I think we have to think more broadly and widely as consumers ourselves, and also as those of us who are perhaps selling products to the public or services, or speaking about the work that we do, think about the ways in which those statements may be perceived, understood, or misinterpreted, for example. Next slide, please. So in the United States, we don't have a federal law on greenwashing, but we do have the FTC Green Guides. Per Section 5 of the FTC Act, the FTC has the authority essentially to regulate misleading or deceptive advertising. And so they have issued interpretive guidance that has been used for decades on how marketers can make benefit claims less misleading. And so typically, if there is litigation, courts will look to the Green Guides as really persuasive authority on whether a claim, at least on its face, could be considered misleading or deceptive. Unfortunately, as I mentioned previously, this space has moved very quickly, I would say, in the last 5 to 7 years. And so the last time the FTC issued new guidance was in 2012. And so the guidance we have is very outdated. In 2022, the FTC underwent a process through a notice and comment period of revisiting the guidance and really communicating with the public about what claims should be added, right? How do we improve this process so that it is relevant, salient, and sort of meeting the industry where it is. I think our language and understanding and expectations around recyclability in general has changed tremendously in the last 5 to 7 years. And so we need to think about new guidance and new claims perhaps that should be added. And so that comment process actually was extended because of the interest from industry and the number of comments, and eventually closed. And then we had an election and we have a new president. And so it's unclear whether the FTC is going to issue new guidance at all. And so we are left with the 2012 guidance, which, again, not the most current given how quickly things have changed, but it's the best we've got. So on a federal level, typically that's what folks are typically looking at. Aside from that, depending on sort of where this issue or how this issue may be arising, you also have state Consumer Protection Act statutes as well, which is something that I always advise companies to take a look at. And in some states, those have been amended actually to become more plaintiff friendly, and to sort of give plaintiffs a longer statute of limitations or broader causes of action in this arena. But I think that greenwashing particularly is something that the courts have been more quicker to decide than our executive branch or the agencies have been in terms of giving us policy. So I think another sort of area where you can get a wealth of information as to how a court may decide or consider the issues is to look at applicable case law on the issue if there's any. Next slide, please. So I threw this in here because I think that it's a good example of how mandatory disclosure in some sense can raise the greenwashing stakes. So a few years ago, California passed a series of bills aimed at the mandatory disclosure of climate risk, and also the mandatory disclosure of greenhouse gas emissions. And each of those filings or documents are going to be public. And so people are going to be able to ascertain and dissect and compare, right, statements companies are making about their financial risk and how they plan to mitigate them, and also about their emissions inventories. And so it creates sort of a critical inflection point here where companies, again, need to be mindful of making sure that their messaging is consistent and accurate. And aside from the mandatory disclosure laws, California also passed a voluntary carbon market disclosure act, which essentially requires companies to make public disclosures on their websites if they are marketing or selling carbon credits or offsets, and also if they are engaging in mitigation of their climate emissions. And so that's just another example of companies having to communicate directly to the public and needing to be mindful, right, about what they're putting in those statements and the accuracies of them. And the AB 1305 actually emboldens the public to approach companies to ask for substantiation. So if you set a net zero emissions target goal in 2023, a member of the public could approach the company and ask you for substantiation on how you plan to get there and whether you're on track, right? That's another area that companies sometimes run into trouble with, where they'll set goals but not monitor whether they're on progress to meet them. Next slide, please. Again, Thompson Hine is a law firm. We have great relationships with counsel outside of the United States, but I think it's also important to remember that if you are doing business in the EU, there are a number of laws there and guidance as well that is more specific and actually more recent that will serve as guardrails in terms of developing marketing campaigns and sort of response interactions with the public with respect to greenwashing. The same is true for Canada. I think the guidance there was issued, I believe it was this year. We also, again, work with Canadian law firms that can perform sort of the requisite analysis or provide any tools that you may need in terms of legal counsel on those fronts. But again, it's important to think of it more broadly and not just a US issue, because many countries, frankly, are, I think, a bit further ahead than the US in terms of having a unified system, whether it's consumer protection laws or anti-greenwashing guidance more generally. And there have been pretty large verdicts, particularly in the aviation industry, in the EU with respect to greenwashing. So that risk is global. Next slide, please. I don't want to take up too much more time, but this greenwashing assessment, I think, just underscores again that really it's a all hands on deck, right? You need to have many different stakeholders from different parts of the company at the table, and it has to be an ongoing sort of discussion. You don't just do an assessment and then you're done. As the business continues to evolve, it's something that needs to be continually and really constantly thought of and addressed. And like I said, with the proliferation of mandatory disclosure, the risk continues to rise, I think, for companies to fall into potential pit holes. So this is just another example of different types of greenwashing risk and different indicator questions that may open a discussion perhaps with the team of potential risk, whether they exist, and maybe how to get in front of them and mitigate them. Next slide, please. And this is another one, and I think for different seasons of the year, some risks may be more pernicious than others. So for example, political spin maybe during the election times of year, maybe something you might want to delve into a bit more broadly than general misleading statements or jargon or vagueness. Next slide, please. So generally, again, defending against greenwashing risk really is a company-wide approach. These are just some strategies in the toolbox that can be used. Using consultants, making sure you're reviewing your supply chain contracts, making sure that perhaps you have a code of conduct for your suppliers, making sure that the right employees have the requisite training. Diversity, again, very important. People that have different perspectives can see risk very differently. Reviewing claims for truthfulness periodically, again, is another good way to make sure that as the business grows, etc., that you have constant eyes on how that may be impacting previous statements. And I think keeping abreast of the states in which business is done, making sure you're aware of sort of what's going on in the legislatures at that level, continuing to monitor obviously the greenwashing case law in the United States as well, and thinking more globally if you do need global partners to assist with greenwashing risk in other countries as appropriate. Next slide, please. And then these are just some other considerations. Obviously, crisis communication strategy. If there is an issue, you want to be on the forefront of that before you land yourself into trouble. Using trade associations to see sort of and keep tabs on what your peers are doing, I think also is a big one. And also that can help you with lobbying efforts as laws emerge. You have more of an opportunity to sort of influence the policy as it's made. And many folks usually utilize trade associations to do that as well. So I will end here and I will hand it off to Julie, who will be talking about AI washing.
Thank you, Tanya. So AI washing, we'll first set the table of what we're talking about with respect to AI, talk about what AI washing means, talk a little bit about the legal framework that oversees the enforcement of AI washing out there, and then end with defending against AI washing and some tactics to be mindful of and be able to utilize. So when we talk about what AI is, this hopefully looks familiar. Robin and I worked closely to make sure that we are pulling in Honeywell's AI documentation. So this is from your responsible AI policy, the definitions of what we're talking about. And we're not just talking about the generative AI, the chat GPTs and the journeys that everybody's really familiar with of the more recent type, but we're talking about all AI systems, both generative and traditional AI. And so when we talk about claims that you're making relating to this technology, the technology we're talking about are machine-based systems that operate with varying levels of autonomy. And they sometimes have adaptiveness after deployment, but they infer based on whatever inputs you're putting in, how to generate the outputs that you're looking for, whether it's predictions, content, recommendations. And so this, when we're over the next 10 minutes or so, this is the technology that we're focusing on when we're talking about AI washing. And so what is AI washing? It's an AI claim that is made about a product or an internal system that could be seen as false or misleading. And similar to what Tanya went through with the greenwashing, there's a lot of different types of AI washing. And I think for the most part, we could probably mimic a lot of the ones around the circle that she just showed. But the four biggest ones that I tend to look for and tend to see as potential issues to make sure clients are really clear with what they are putting into their marketing and other communications relate to capability inflation, vagueness, false labeling, and investor-facing misrepresentation. So when we talk about capability inflation, those types of AI washing are the ones where you're saying the system can do more than what it actually does, or that it's AI powered when it's not AI powered. And so really understanding truly what a technology does and what it contributes to, either the technology on its own or how an organization is utilizing technology. Because I think a lot of enforcement actions that we'll go through some examples really talk about service providers that are inflating their capabilities by saying that they're utilizing AI when they're not necessarily using it. Vagueness is also problematic that you'll find is another type of AI washing where they're not very clear about exactly what it is. They're just AI powered. I'm sure you see dozens of that every day as you're looking at different technology, or you're hearing new companies out there. AI powered, what does that mean? What does it do? Especially on the commercial contracting side, I can't tell you the number of times I get a contract that's like, oh, this is an AI powered tool. Great. What does that mean? What does it do? What data does it utilize? What aspect of it is AI? Right? Really digging in to understand is the vagueness is part of the problem that can result in an AI washing claim. False labeling, similar to what we were just talking about with capability inflation, but sometimes it's just completely false, and they're not just over inflating what they're utilizing, but they just are patently lying about it. And then, especially on the SEC side of things, investor-facing misrepresentations that can come out is another type of AI washing that we want to be mindful of as we go through the process of evaluating claims that we're making on behalf of the organization. And so, before I get to this slide, I'm going to go back a moment. I want to talk a little bit about the frameworks that exist, and they're very similar to what Tanya walked through on the greenwashing, because again, in the United States, we're looking at the FTC's Section 5 rights to enforce against deceptive advertising. They've made clear that there's no AI exemption, just you can't misuse AI. It's treated like any false claim that's out there. And then in addition to the FTC, we've got the SEC that is, you want to make sure that there's a reasonable basis for any AI-related statements, and false claims can violate anti-fraud and marketing rules. And then there are other agencies out there, as Tanya also mentioned, state attorneys general pursuing fraud actions or security violations if there are AI claims relating to any scheme. And the DOJ also could get involved as well. Outside of the United States, as Tanya mentioned, there are frameworks in various parts of the globe that you'll want to be mindful of as you're looking at claims that might show up outside of the United States and be seen in the EU, the UK, Canada, etc. In the EU, we've got they have various consumer protection laws, both, for example, German and French regulators have applied unfair practice rules to all type of technology claims, which is going to cover the AI washing claims in the future. And the EU AI Act, we'll talk about an example in a moment. And while it doesn't have an explicit outlaw of AI washing, there's really strong transparency requirements in there that really are going to require people to make statements. And just like Tanya was saying, these mandatory disclosures and mandatory transparency obligations really put entities at risk of wanting to comply with the law and needing to ensure that they really understand exactly what supports the claims that they're making about their technology or the use of the technology. In the UK, there is the Competition and Markets Authority that enforces the consumer protection laws. And there was a recent 2024 act that came out, the Digital Markets Competition and Consumers Act, that does have very hefty fines, up to 10% of global turnover, for false or misleading advertising. And this does include claims relating to AI technology. So you want to be mindful, especially if you have claims relating to these AI components or functions. Canada similarly has a competition act. Again, you'll see this across the globe, like any of these consumer protection acts really have these different prohibitions on false and misleading representations to make sure that we are not misleading consumers out there. So in terms of some examples, I think these SEC ones on the right here made pretty big headlines in October 2024. And I think the reason was because the SEC coined the term AI washing in 2024, and everyone's like, what is this? This is a thing, we need to be worried about it. But it's not a new thing, right? Like there have been, and that's why I wanted to pull some of these early enforcement actions, like as early as 2011, going back, you can see that there are claims about AI software that resulted in enforcement actions because they just were false. And so in addition to the SEC settlements that are out there, different enforcement actions they've brought, the FTC has been really active as well. They regularly have, they've led to multiple actions out there. I think one of the most recent ones is a proposed order against Workato, which it was just in April of 2025, and they had an AI content detector that claimed 98% accuracy for spotting AI written text, and the FTC found no reliable evidence that it did that. And so they're going to really require Workato to stay on top of them to test what their product does and ensure that it actually does what it claims to do in order to have accuracy within the advertising that they put out there of what their software can do. And I wanted to pull this recent action relating to coming out of the EU. It's not an AI washing case, and I'll be upfront and honest with you about it. But what I think is really interesting about this case is it's one of those like first couple of cases that is having some type of interpretation of the EU AI Act, which just went into effect recently, and we still don't even have the full impact of the law that is in enforcement just yet. That's coming mostly throughout 2026, with some dates later in 27. But what this case is looking at the interpretation of what is considered AI. And the case surrounds the use of a random case allocation generator that a judiciary group was using. And they weren't sure whether or not, and there's all these claims about, was it biased, was it discriminatory, was it operating in the right way, was it allowing people to have speedy access to justice. But at the end of the day, what relates to what we're talking about is people weren't clear on whether or not this was an AI tool, and if it is an AI tool, it would be considered high risk, and then what are the compliance obligations that they have to utilize in order to meet the EU AI Act's requirements for the high risk tool that they were using. But what I find really interesting is it's unclear what exactly is considered an AI tool right now. And so that, I think, puts a lot of questions out there about what is going to be, like you could end up saying, I didn't think this was AI, so it's unintentional missing what you're stating, like false labeling that it wasn't AI when it actually was, or intentional use of the gray area, saying, look, we know that it's gray right now, but we're going to get away with it because we can say this is an AI tool, and we in good faith thought that we were trying to comply and say it was AI. So I think the grayness in the definition of AI is problematic. It looks like I'm losing connection. Can you guys hear me okay still?
I can hear you.
Okay, great. So let's move on to the next slide. Whoops.
Hey,
Okay.
Julie,
Yes.
Robin. Just so we're clear, when you shared our definition of AI, that's why our definition comes from the OECD, right? And is part of the EU AI Act, and it's very broad, is for these exact reasons, right? That you mentioned.
Perfect. Yeah, no, thank you for sharing that additional context. That's spot on, and it's exactly why it is totally up for interpretation right now, and we'll see how it goes. And it might land how greenwashing has landed, where there is no consistent and clear definition, and then we're looking to the court systems to provide that clarity. Okay, I have lost a lot of controls. I don't think I'm in it anymore. I don't know what happened. I can't move the slides forward.
Scott, are you on and can you move the slides forward?
Diane, you can still hear me, right?
I can totally hear you, but I can't do any of the slides.
Okay. Sorry about that. Let me see if I can go grab Jose. And
yes, Julie, you're still in control of the slides, but if you want me to, I can advance. Just say advance.
yeah, you can advance, please. That would be great. Apologies, everybody. And I can't see if it's advanced because right now it's still on the old slide. But I have it pulled up on my slide. So we're just on my last slide, which is great. Did you advance it, Scott? Yeah, okay. So defending against AI washing, similar to what Tanya was saying, there's a lot of different things that you can do from a protection standpoint, from governance, disclosures, and due diligence. One thing I want to point out on the disclosure side is Honeywell has built a really great and strong process in place for having any claims relating to AI go through an approval system. So make sure that all AI claims are filed with the Honeywell AI claims approval system. And so we'll go back a couple slides here. I'm going to just go back, Scott, really quick. Sorry, guys. Here we go. So yeah, the Honeywell AI claims system, approval system, please use that. Any claim you see that relates to AI claims, it's incredibly important to do that. But the biggest takeaway I have is anytime you're working with any claim relating to AI, you got to do a deep dive of the technology. You got to understand it. You need to know what it is, how it works, how it's going to be utilized, so that you can really make sure that you're appropriately describing what it can and what it can't do, so that you're not overstating it. I think that's the biggest takeaway is it really requires a solid understanding of the details. And make sure that you're doing a full life cycle analysis of any AI usage. And this kind of ties back into the greenwashing side. We've actually seen some issues where companies are ignoring the environmental aspects that it takes for training the kind of the power usage and the water usage that comes from training their AI models, and they don't take that into account when they're doing their environmental claims. And so there is a little bit of a tie that you have between the greenwashing and the AI washing. So really understand the full life cycle from, like, if you're doing any development, from the development all the way through the monitoring, and what does that really take? Not only what can it do from an AI side, but is there an impact on the social side or the greenwashing side that you need to be mindful of as well to take it into account. And with that, and apologies for my technical difficulties that I hope were only seen on my end and you all got to hear me talk about it out loud, I'm going to hand it off to Francesca to talk about social washing.
Thanks, Julie. And I'll take a minute just to remind people that if you have any questions, you can type them into the question boxes, which we know work, unlike the chat. So please put them in there. We'll try to answer as many as we can at the end of the presentation. And I, for one, love questions, so I hope you come up with some good ones. But so social washing. I'm going to focus mostly on forced labor when we talk about human rights, but social washing could cover an array of sort of human rights and social responsibility claims. Let's move to the next slide. Since about 15 years ago, there has been a significant increase in human rights laws and forced labor laws. And I'm throwing this slide on there just to put this all into context. And there was actually a UN agreement that most countries signed on to back in, I think it was 2010, and many of these actions that you see rolling out come from that. We've got California back in 2012 passing their Supply Chain Transparency Act, which required companies to make public statement about what they were doing about forced labor and child labor in their supply chains. I won't go over all of these, but I will note that the German human rights law, which went into effect a few years ago, has had a very significant impact because of the required disclosures about human rights, as well as other matters that we've touched on. The Uyghur Forced Labor Prevention Act is not a disclosure-related requirement, but it did create a presumption of forced labor if material is sourced from Xinjiang or by companies that have been labeled as essentially using Uyghur forced labor. And that's the UFLPA entity list. So it created a presumption, which means that there's presumptively more forced labor going on around the world. Many of these are going to have, again, disclosure requirements and sort of transparency requirements. So you're going to have more and more disclosures being made about what companies are doing to mitigate the risk of forced labor or child labor in their supply chains. Next slide, please. There is a definition of forced labor. Yay! It's not like artificial intelligence. So these are the 11 forced labor indicators. Okay, I said there was a definition, but really it's a question of how many of these you have and how prevalent they are. Some of these people will look at and they won't necessarily think of them as forced labor, excessive overtime, for example. Or retention of identity documents. You might not on its face think of that as forced labor, but the International Labor Organization has done a lot of research and surveys, and these are conditions that they find generally go hand in hand with people being pressured into labor. So if you don't give people their identity documents unless they do work for you, if they are somehow required to pay off a debt to come to your location and work, like they had to sort of go into debt to pay their own travel expenses or something like that, that is considered a type of pressure, and it becomes forced labor. Next slide, please. Wait, we can go back one. So I talked when we were looking at that little arrow about the different type of forced labor actions, but I think I should back up a step and point out that when we talk about artificial intelligence, AI, when we talk about sustainability, those are things we want, right? So mostly people are trying to claim that they are doing those things. When we talk about forced labor and child labor, we don't want those, and people are trying to claim that they don't do them. However, there's also a number of prohibitions on it from different angles. So there's an import restriction in the United States. Other countries have import restrictions like Canada. The EU is working on an import restriction. So it's not just a matter of sort of marketing claims for certain reasons, but there are prohibitions on it. There are sanctions that can be imposed on companies that engage in forced labor. There are affirmative requirements to conduct due diligence related to forced labor and human rights. That's going to be in the EU. And then there are disclosure requirements, which are about the steps that you may or may not be taking in order to prevent forced labor. Mostly the disclosure requirements do not require you to say that you're doing something. They just require you to be honest about what you are doing. Next slide. So what is social washing? So like its counterparts, it's presenting a facade of social responsibility in the human rights context without sort of substantiation or tangible actions. This means this can go beyond saying that you don't have forced labor or child labor, which are very, very difficult to dispositively prove one way or another. This can go beyond that to say that you're taking steps to try and prevent it, that you're actively involved in performing due diligence on suppliers, that you are part of the coalition of the willing and good people on this planet to implement steps to remediate child and forced labor when it's encountered. So those are typically the things that would be considered social washing. And I think I have an example on the next slide. So this is a recent lawsuit. It went up to the Supreme Court, it's been all over the place. To be honest, I don't know the current status of this suit because of the different appeals. But it was a lawsuit filed against Hershey and the Rainforest Alliance. And it alleged that the Rainforest Alliance was putting its like little stamp on Hershey's products because Hershey participated in their social auditing and certification program. And one of the issues, was sustainability, but a big part of that sustainability was child labor and forced labor and farmer poverty. And the Corporate Accountability Lab basically said that the audits weren't valid. They weren't worth the stamp because people were skirting around them, having children go home the day the auditors were coming and then bringing them back the next day, that kind of thing. And so they sued both the Rainforest Alliance for creating this scheme, but also Hershey for putting it on their products and inducing customers who wanted to support socially responsible organizations to buy their products. Next slide. And I'm going through this pretty quickly, but I hope people feel free to ask questions. We've got a little bit of time in a moment. So how do you defend against social washing? This, I think, is a little different than greenwashing and AI washing in that it is, it's like there's two parts. You're obliged to defend against human rights violations. So there should be a backbone of compliance that requires you to attempt to mitigate this. Then you want to add on top of that the piece that's the social washing piece, which is you don't want to make false claims and you don't want to be overinflating what you're doing. So here you want to have, again, from a governance point of view, enterprise-wide policies and procedures specifically about the types of claims you can make, about the disclosures you're making. So we're going above the compliance bedrock, the anti-forced labor compliance bedrock, to the promotional, like what can you say about your products? You want to have training not just to prevent forced labor, but to make sure that if people are making these disclosures, they're accurate, they're transparent. With mandatory disclosures, again, you want to be careful with the language you're using. this is all very much like what Tanya talked about and Julie talked about in other contexts, but you want to be careful not to say that you've done something, you've conquered forced labor, but describe the processes accurately that you're putting in place to try and mitigate it. Then with due diligence, again, this I'm trying to go beyond due diligence of your supply chain, which is its own process, into sort of reviewing and diligence about the claims that your vendors are making. See if they're participating in various certification programs that may or may not be legitimate, might be considered, to test the sort of claims that they are asserting that you might roll into your own. And just as a best practice, make sure you are being realistic about the ability to achieve your sustainability goals in a human rights context. And so that the goals that you are promoting, where you choose or are required to promote them, are realistic and attainable based on what your vendors are doing and telling you. So that, I think, might leave us with some time for some questions if anyone has some. But we can also discuss a little bit more about implementation of some of these programs as well. Can you move to the next slide?
So I had one question for you, Francesca. Of those 11 factors, is there like a threshold of how many you need to meet, or is one enough for it to be considered forced labor?
It's somewhat subjective, but yes, one of them is enough. It would depend on the severity of what they were doing.
Cool.
So certainly, like debt bondage is considered, it could be severe. A little bit of excessive overtime, probably not.
Yeah, okay. Thank you. I was thinking at the end of your slides, as you were just finishing up with your talking points, Francesca, it made me think about kind of the, how do you capture this information, right? The information needed for greenwashing and social washing and AI washing, especially when you have vendors and third parties involved that you're relying on to get the information from. And I think a lot of it, when you think about how do you operationalize that and collect the information and then make sure you get the right information to the right people. I know Honeywell has some fantastic processes in place. And I think, Robin, if you want to jump in to share a little bit about on the claim review process, feel free to do that. But before we even get to the claim review, I think a lot of it comes to evaluating your relationships at the beginning of those relationships and really digging in on the due diligence side of who are you partnering with, who are you working with, what are they doing, and how are they doing what they're doing with you. And so I think I've seen a lot of my clients update their vendor procurement questionnaires to incorporate questions relating to the supply chain transparency, relating to forced labor, trying to identify some of those red flag issues that would come up kind of at the beginning so that it can be appropriately flagged. And similarly on the technology side, digging in to really understand what is or isn't AI. And I'm sure likewise, I've seen it also on the greenwashing side, really understanding what they use, how they use it, and what claims they make in their marketing materials to you as a vendor, and digging in to make sure that it's actually truthful. Tanya, Francesca, I don't know if you want to share anything that you've seen on the gathering the information side.
I do think gathering the information is very important. What I have seen some companies struggle with is the overlapping but not entirely harmonized reasons for which they need to gather information and the life cycles and the disclosures. And so I think as a best practice, trying to lay all of those out so you understand where you need to be talking about these things, right? What disclosure requirements you have, where you might be making sort of investor or marketing type claims. Lay that out and then try to collectively aggregate the information you will need to respond to those different channels.
Yeah. And then I think making sure that, oh, Tanya, you're on mute, sorry.
Yeah, I think some of it starts with, the materiality assessment, frankly, right? Because, the company obviously has to determine sort of what risks are material. And then working from there, I think trying to make sure that you have the right stakeholders in the room, right, to identify sort of the pathways for various risks. And so one of the key pointers for us before we even get to data is, do we even have the right people at the table to have the conversation? And that may be something that you have to continually ask. And so we're big on telling our clients to think of ESG like a council, right? That is made up of representatives from throughout the enterprise.
Perfect, thank you. Robin, before we close it up, I wanted to give you a chance to share with the audience a little bit more about Honeywell's specific processes relating to the claim reviews, or anything else that you want to share too.
My understanding is on as well as David. Just a couple of quick points that these types of topics are definitely covered with Honeywell, right? We have them included in our code. We have them included in our supplier code. That's in truth of all three, right? And then to your point, we also have claims monitoring systems, right? And so that's also in place for ESG and AI claims. So I know that these are fully embedded. I don't know, Tanya, if you have anything more you want to say about ESG.
I think you guys covered it really well. We have the tool that everyone's supposed to use for any quantitative substantiations. Otherwise, we ask people to please seek legal guidance when they want to have any other adverts put out there that might have non-quantitative claims. And I think with the social washing, one thing to consider is how we are speaking about tariffs nowadays. So we are putting out a lot of supplier resiliency statements, documentation. So we want to make sure that we can really back up the claims that we're making so that we don't fall into any sort of social washing claims where we might be putting pressure on vendors to find new sub-suppliers, and then we haven't done the full deep dive vetting process that would be expected with the short turnaround time. But thanks for the opportunity, and thank you so much for the presentation today.
And we really thank you so much for joining us today, for having us, to David and the Honeywell team for bringing us in and working in partnership as we put the presentation together. It's been a really fantastic collaborative effort, and feel free to reach out to any of us or to your Honeywell contacts if you have any questions. Thank you again.